Good morning, folks. My name is Richard Edgar. I'm a lawyer in town. I practice criminal defense law, and I love cleaning up people's criminal histories. Today is a seminar on a criminal set-aside. So everybody's heard of the word expungement. And in expungement, next slide, please. Back in the good old days, when a record was expunged, the judge would look at you, congratulate you, hand you your file back, and you go have a big burn party, and nobody ever knew about it. But that's a long, long time ago. There is no expungement today in Arizona. There are many forms that are proposed through the legislature, but over the recent years, none of them have been passed. So instead, what we have is a set-aside. And with a set-aside, that's where, if you wouldn't mind, this is all done by statute. And when I say it's done by statute, everything's got to fit inside of a little place. It's got a little file where it goes. And if it fits inside that little peg, it's going to be allowed to be set aside. So every person convicted of an offense has a right pursuant to this statute. It shall be informed of this right at the discharge of probation or at the discharge of the case as to whether or not they have the right to set aside their conviction. And generally, when you're cleaning up your own record, you got to look at what kind of situation are you in? Who can file this paperwork? Of course, you can file this paperwork because you can also represent yourself in a court of law. However, if you get placed on formal probation because of your conviction, and at the end of the term of your formal probation, even your probation officer can file this on your behalf. Or you can hire an attorney to do the same. And if the judge, and it's generally the judge that sentences you that does this set-aside for the courts, if they grant this application, it may be done, you're going to be released from all penalties and all disabilities except those imposed by, there's a bunch of little tiny pieces of the statute that you're not allowed to set aside. For instance, Title 28. Title 28 has to do with the traffic code. So when you're dealing with the traffic code, there are certain things that you just cannot set aside. That's what the law claims. That's what the legislature in Phoenix has determined that is not going to be allowed to be set aside in the state of Arizona. Failure to appear for court pursuant to ARS 3308, you can't set that aside, but you can set aside a DUI. For some odd reason, I don't know why, it just doesn't make too much sense. But if you look inside the statute, it'll tell you which pieces you cannot set aside. There are certain provisions in game and fish. You kill too many birds, you catch too many fish, you can't set some of those things aside. Next ones. And like I said, there's just a bunch of exceptions in there. They're usually little obscure statutes, so they won't apply to the vast majority of people. But I'm just informing you, just in case you run into a situation, there are some exceptions where you cannot set something aside. So for felony convictions, the process is a little bit longer than with misdemeanor convictions. It's a 2-page application, which is super simple to fill out. And once you file this, and you go through and you just have to put down a few pieces of information, once you fill this out, you can file it all on your own. You don't need a lawyer to do any of this stuff. Page 2, please. This next form, and I'm just showing you guys these forms because we have these available for you after the clinic if you need them. This is a misdemeanor form. This is a 1-page form, and this form is your petition, and it's also the order all in one piece of paper. The reason I like these is a lot of people get convicted of misdemeanors. Not so much felonies, but misdemeanors, and they're the little tiny piece that they have to clean up to go get a job, to go make application for a government position, to get something for a background clearance. Maybe you want a Century Pass at the border. These are going to be the pieces of paper that you need. These are unique to each court. However, this form right here is used in all of the misdemeanor courts in Yuma County. And again, the information that's needed on here, I'm going to show you after this how you can get that information for yourself. And like I said before, This bottom piece right here is the actual order that the judge is going to sign. So if you're going to be holding on to a piece of paper that's going to be cleaning up your criminal history, that you're going to be showing to employers, you're going to be showing to educators, to whomever, all you have to do is have this one sheet of paper that you're going to include with your application, because it's going to say explain. You just include this one piece of paper with the application and you're going to be just fine. And it doesn't matter if you've got 1 or 20 of these suckers, you're going to want to do one for each and every one. Next slide, please. So this here, I'd say about close to 20 years ago, Arizona got into public access. This is all regulated by the Supreme Court of Arizona. Public access allows the public to access court information. These guys are on the top of the charts with regards to technology when it comes to looking up people. Arizona's at the top. So look yourself up, look somebody else up, especially look yourself up, because your employers are going to be looking at that as well. Public access is easily, but how many people in here have used public access? Oh, it's a wonderful tool. Not just because I'm an attorney. I use this thing probably 20, 30 times a day just looking people up. You Google Public Access Arizona and it's going to get you to this page. Once you get to this page, you just fill out whatever it is to get you into wherever you got to go. And it's a big query system. And the query system is last name, first name, date of birth, and court. Believe it or not, it's a great query system. And if you want to find somebody in a system, you can find them. There are a few situations to where they're not in there, but about 99% of the stuff that I look up that I know is legit is in there. Usually, if you're looking somebody else up, that's the tough part, but you're going to know all your information, so you're going to be able to narrow yourself down. And the reason it's important to look that up too is when you're filling out a set-aside, these things aren't general. So if you get convicted in California, you cannot file a set-aside in Arizona and think that that's going to work. You have to go back to the court where you were convicted. So if you were convicted in San Luis Municipal Court of DUI, you can't file it here in Yuma. It's got to go back to San Luis Municipal Court. So here's all the jurisdictions that are in Yuma County. Whenever you're looking up a case inside of public access and you find the sheet that you want, everything on there that you want, it's going to give you all the information you need to fill it out for public access. This is the contact sheet that's going to show. So you're going to be able to find out the exact court that you need, the exact court's form that you need to fill it out. I've never dealt with a court in Arizona that would not take these by mail. So say, for instance, you had a fun weekend in Winslow, Arizona. You got a little ticket in Winslow, Arizona. You just pled guilty the next day after they let you out of jail. You don't know how to clean it up, but you don't want to go to Winslow, Arizona. You just call them up, ask them what information is needed, and if you're missing anything on the form, they'll give it to you. But this right here gives you all the information you need, all from public access. So as mentioned before, each court does require a separate set of forms. The main two different forms are going to be your felony forms, which are going to require some more information than the misdemeanor forms. And then all the other ones are down below. I'm going to address the juvenile forms kind of at the end. Here we go. And this is the one, this is the big ticket right here that gets most people. Your sentence must be complete before you can have your conviction set aside. So I punch you in the face real hard, breaks your nose, and you got $10,000 worth of hospital bills. I am that strong. I go to prison. I get out of prison. I finish my community restitution. I still got to pay your restitution. So until my restitution's paid with you and all my fines and fees are paid, my sentence is not complete. So your sentence has to be totally complete. So once you fill these forms out, you do it all by hand. There's no fancy computers. There's no fancy notarios. There's no fancy scribes. There's no fancy handwriting. There's no fancy suits or ties. Once you fill this out by hand, you can walk it up to the clerk's office and hand it to them, and they have to process all of this paperwork for free. All of this is free. Tell your friends and neighbors, this is all free. All it takes is a little bit of your time, free. Each jurisdiction has their own clerk of the court. In this building, in the neighboring building, there are several jurisdictions, or a couple of jurisdictions. We have two separate clerk's offices in the building next door. We have one for Superior Court, and we have one for Justice Court, Precinct 1. Each clerk's office has multiple people working in there, and they all know what they're doing. And each clerk's office has the ability to look your file up. They have the ability to do a lot of things. So if you need any information that you cannot find on public access or that you do not have in your own personal records, you can always check with each clerk of the court. And you may want to do that anyway, just to make sure that you're filing your paperwork in the right court. So let's speak right now to the felony set-aside convictions. If you're going to file a set-aside for felony offenses, you're going to make sure that all of your stuff's done, all the restitution's paid, and you can actually set aside this conviction. You're going to file a packet. The clerk's going to take that packet, and they're going to make several copies, and they're going to distribute these copies out. The first place that they're going to send a copy to is the Department of Public Safety. The Department of Public Safety is in charge of running your criminal history. They're also the ones in charge of the fingerprint clearance cards. They're also in charge of background checks. These people are doing a background check on you once you file your set-aside paperwork. What are they looking for, people? Anything under the rocks. They're going to look to see if you went to Ohio and were a knucklehead, or if you went to some other jurisdiction. Whatever it is, they're going to be able to find it through something called NCIC, National Criminal Information Center. That's where everything is housed, and they're going to be able to find out if you have been convicted of anything prior to and or after the actual sentence. The next one is the probation department. My personal opinion, the reason they send this to the probation department is to see what kind of a probationer that you were. I mean, maybe you were a knucklehead. Maybe you were the best probationer to ever go through. Maybe you went through probation and you ended up leading the counseling sessions and you got terminated early and you were just fantastic. Or maybe you had so many speed bumps that, good God, don't let this guy go just yet. We need to keep him on the hook for a while. I think that's why they send it to probation, because probation is the one that really deals with the folks afterwards. They're also the ones that are in charge of discharging them from probation. And they're the ones that they're intimate with each and every person that goes through probation. The county attorney's office. I mentioned NCIC, that's where they're going to look people up to make sure that they've been good boys and girls. But when you're looking at the county attorney's office, the reason they send it to them is not only are they going to do a criminal history on them, the county attorney's office is more than likely to be in charge of any investigations. So if somebody's been under investigation for a drug trafficking ring, and they know that they're guilty of this stuff, but they just can't prove it, they're going to throw in their 2 cents. Or maybe this person has been charged with many things, but never convicted of anything. They're also going to be able to give their 2 cents. The county attorney's office knows a lot of things that the general public does not know. And lastly, the most important person that receives this is the judge. And this is generally your sentencing judge. So if you were sentenced by Judge Kenworthy back in 2010, this is more than likely going to go back to Judge Kenworthy in 2018. But if Judge Kenworthy happens to no longer be doing those cases, it's just going to go to a different judge. So I always figure it's going to go back to the sentencing judge unless that judge is no longer there or assigned to different duties, then it's going to go back to a different judge. And that happens all the time, just because a lot of times that people set aside their convictions, it's done years after their conviction. And the judge is just no longer there. So the judge has the final decision once everything comes in. And the judge has basically 3 options. They can flat deny it, they can grant it, or they can order that a hearing be set. Now, if your application's denied, you have to think to yourself, why is it being denied? Just like I mentioned before, if it's a crime of violence, or if it's a crime of moral turpitude, or if it's a crime where you ripped a bunch of people off and they all went hungry and poor, it's really going to matter of what you were convicted of and kind of what the judge saw in you and the case as well. So if you're denied, you may want to rethink it. For example, I've had clients that were denied 5 times on a set-aside. But my client was also involved in a pretty bad shooting where somebody almost died. And it was a shooting involving a gun. And he wanted his gun rights back. And the judge just refused and refused and refused. So I filed a brand new set-aside on the same day every year. Every year we'd file the same one. And finally, after the 5th year, and this was 15 years since the guy's conviction, 15 years afterwards, the judge wanted a hearing. And the judge wanted to see the whites of his eyes, and the judge wanted to hear his story. And his story was compelling. And after the judge heard his story, the judge granted him his gun rights back. But it's just one of those situations to where if you're denied, think about it. Why were you denied? They don't always put on there why they deny it. Most of the time, it's just a flat denial. But sometimes they'll give an explanation. This goes back to the question is, what happens if the set aside is granted? You can't put your head in the sand and just kind of forget about the fact that you're a convicted felon forever. This set aside does nothing to change the fact that you're a convicted felon forever. So when you're filling out the applications, answer the question. Have you ever been convicted of a felony? I've never been convicted of a felony, so I can put down no. But I've been convicted of a lot of misdemeanors. So I'd still put no. But if I had to answer the second question, you have to answer in the affirmative. That's always my opinion. As a criminal defense attorney, I've represented people, many people, for lying on applications, especially to law enforcement, government agencies, people of that nature. They don't only take it seriously, they get ticked off. And if they get ticked off, they can actually, you can be charged with a crime for lying on application for DPS. So it's always my opinion, you always want to be truthful for these people, and you never want to be looking over your shoulder. And if they don't want you, move on to the next job. But just have all your ducks in a row and all your paperwork in a row. And it's just one of those situations too where if employers are looking at a stack of applications, they're going to go into 2 piles. The one pile is going to be people that are clean, and fit all the criteria. And then there's pile number 2. And if you've been convicted of a felony, more than likely you're going in pile number 2. But pile number 2 doesn't mean you're done. That just means that you're only done if they take all the first applications. So it's always my suggestion that if you're going to do it, always include the necessary paperwork in there so there's no guessing. So if they say, have you been convicted of a felony? Yeah, it was endangerment. And the only reason it was endangerment was I was drinking and driving, and I ran into a pole. And that was 15 years ago. And here's all the paperwork and the set aside and stuff that I've been doing good since. So just don't ever, ever lie or fib or put your head in the sand when it comes to answering these questions on an application. So what happens if the judge grants a set aside? And you folks in here, if you've seen public access, that's where the vast majority of employers are looking you up. They're looking up your criminal history through public access. When I look people up and I look up their criminal history, I look it up through public access. If the government's looking you up, they have their own secret databases. I mentioned before NCIC. They're going to look you up through NCIC. But anybody else, if you're applying to McDonald's, or if you're applying to Marshall's, or if you're applying to Mr. G's Burrito, they're going to look you up through public access. It's going to change whatever is in public access. It will actually change what would normally be here guilty of reckless driving. It'll change it to set aside pursuant to 13907. This here is a juvenile set-aside form. Not that employers are going to be able to find any of this stuff out, but if anybody needs any information on how to set aside a juvenile conviction, it's all right here. So once a person is convicted of a crime, they may or not lose certain civil rights. The right to own a weapon is lost if convicted of any felony offense or certain misdemeanor offenses. And simply setting aside, simply doing what we're doing here today will not automatically give your gun rights back. So when we give you back all of your civil rights, or when the judge does, through a set-aside, meaning your right to vote, your right to sit on a jury, that does not include a weapon. That is a complete and separate form that I always suggest to my clients, do that form or do that request after you get your civil rights back. So once you fill out these set-aside forms, get your civil rights back, and then I always file this one subsequently. This one here is the big one for all the judges. If you've been convicted of a felony, you lose your right to own a weapon. And no judge wants to give you your right to own a weapon back if you're going to go out and use that weapon to commit another crime. So generally, they're going to want to see some positive activity. Like I mentioned, my client that shot another individual. 15 years afterwards, and the judge didn't want to give him his rights back. But finally, after some explanation, she did. So this one here is generally the toughest hurdle. But it's always my opinion, if you're a citizen of the United States and you can have your right to carry a weapon, get it back. You never know what kind of situation you're going to be in to where you're going to be in proximity to a weapon, a gun of some sort, or you need to use a gun for your protection or whatever. You just don't want to be in violation of the law. If you do not have the right to possess a weapon and you're caught with a weapon, that is a Class 4 felony, punishable by 2.5 years in prison. So when you're filling out this form, this is the form where there was some talk about before, should you put in explanation when you're putting in the set-aside conviction. This is the only form inside of this packet that it's almost required that you fill out, why do you want your gun rights back? So if you could, go back to the form. One page. All you're going to do is fill out, why do you want your gun rights back? Hunting, home protection. My lawyer told me to do it in case I'm a dummy and I have a gun sitting in front of me. However, whatever you want to put down there for that, put down your explanation of why you want the gun. The judge sees these things all the time, and all the judge is going to do is look at it, read it, probably peruse through the criminal history, see where you've been, see what you've been doing, see what DPS's report has to say, see if there's been any incidences in any other state. And if it's been 15 years, even though you shot another man, they may give it back. Next slide, please. And when I say everything into consideration, when you're putting down there, you can also put down, look, I've stayed out of trouble since my last incident, and I really plan on staying out of trouble till the day I die.